I represented a woman once who was injured in what was called the social club. It's basically like, think of like a VFW hall or a Masonic temple, something like that, where it's a group, an organization that might own a place that they have a modest bar at, for example. So she was injured in an incident in one of those places, and they were uninsured. So I opted to go forward with that. The defendant in that case never answered anything, didn't respond to any certified letters, didn't respond to the lawsuit that I filed, didn't respond to what's called the motion for default judgment, where you ask the court to give your client a victory on default because the defendant has ignored all of their obligations. I want to get into the process a little more, but long story short there, we entered a judgment. And about a year or two later, I get a set of papers and a response from a lawyer on behalf of, guess who? That social club or that social hall owner. He or she was a businessman. He wanted to do some business. And for whatever reason, this judgment that we entered and filed against this corporate shell or this entity, he could not get out from under it without dealing with us. The ultimate resolution involved him paying a pretty handsome amount to satisfy that judgment. My client was obviously happy to get something out of nothing. So you have to sometimes be selective and pick your battles carefully, because a lot of times, even if you think you've pinpointed one that's good, it doesn't always turn out that way.